Thank you, Katharina. Much appreciated that I get the opportunity to share a little bit in 20 minutes, so I should actually turn this around so I can keep that an eye on not moving that much beyond the time that I'm granted. Yeah, so I'm a lawyer coming from the financial regulatory side of things. So I had been digging deep into blockchain and crypto stuff, but then lately, since a year, I'm also looking into AI, and since I teach here at the local university, I'm also part of the KI-Werkstatt, the AI Werkstatt of HTW, which is sponsored by the Berlin Senate in order to bring AI tools to the Berlin SMEs. So that's the intersection that I'm at. And I always like, to just very briefly touch upon what you need to consider from the legal sphere when you start using AI. So what topics do we have? Confidentiality, obviously, right of use, IP rights, compliance, and then now also the AI Act at the horizon coming up also already to take into account when developing certain instruments here. We always start with looking at two things, the prompts at the one hand and the output at the other. So when you start prompting, obviously, the first thing that you should always keep in mind is to protect your own trade secrets. There are a lot of things that may happen in that sphere that you might not have considered, like, for example, that somebody could reverse engineer the tool that you use, specifically if you use a free version, to actually find out what you prompted, right? So if somebody is really skilled, they might be able to find out, being your competitors, what you worked with within the AI tool. And that obviously also applies to any non-disclosure obligations you have vis-a-vis your business partners. So business trade secrets that you agreed upon not to disclose, obviously you should not use at least the public AI tools for these either. Then we come to data protection, and it's very interesting that like 2 weeks ago, even an official data protection officer from Germany voiced his opinion that GDPR might not be applicable for AI tools because that's overruling GDPR. I'm not so sure if he's that right with it. There was a huge discussion. If you're on LinkedIn, you will be able to find it. I actually, not so sure what ultimately will happen here in the end, but I can only say that the AI Act itself refers to GDPR. So I don't think that guy was actually correct. And if that was not correct, then obviously you need to take care that you don't use personal data within AI systems unless that usage is permitted. So a lot of people also within the blockchain space always say, well, never touch personal data. I can not really agree to that. You just need to observe the rules set for acting with personal data. Same here, right? If you want to use it, for example, for an HR use case, then you need to comply with the GDPR, which means first instance, you need to inform the people and maybe you need their consent, right? But there will always be ways in how actually to use it. Then on the prompting side also, a question that you need to ask yourself is, are you even permitted to use the tool for your business purposes? In the early days, at least, ChatGPT in the free version did not permit any usage for business purposes, right? So in that case, be cautious who you are telling that you're actually using a free version, because that might actually not be in compliance with the terms and conditions of that tool. Then on the output side, question always is, who takes the responsibility for the output actually being correct? And there's a very, very easy answer to that. That's determined again by the terms and conditions of the supplier, and they always provide for them not being reliable, whatever their tool produces, right? So it's actually you, the user, always being responsible for the output being correct. Same for responsibility for the output not infringing third-party rights. So what does that relate to? Well, you know, the AI tool might come up with a picture which is so close to an original painting or whatever some third party produced that you might infringe his or her rights when using that output. Same relates to text, right? And again, it's solely your responsibility to double check that the output which you aim to use is not infringing any third-party rights. So a lot of clients then ask me, how do I do this? I can actually say, I don't know. However, it's your obligation, right? Then right of use. That's also an interesting one when I first came across it. Who may actually use this great slogan that this AI tool just produced for me? Well, maybe everyone, right? Because IP rights only come into existence when there is a sufficient human creativity involved. And if you did not prompt for like a couple of weeks to actually get to that result, there is quite high likelihood that courts would say, well, that's a machinery-produced thing. Everybody can use it. There's no IP attached to it. So also for BD departments, you know, be aware if you produce these things with an AI tool, you might not be able to protect it. All right. Yeah. Then we turn into compliance, which is also an interesting topic because it's actually everybody's managing director's obligation to ensure that their entity is acting in accordance with the current laws. How do you do that? You create a compliance management system. And that's actually the same as with any other compliance management system out there as well. No matter, you know, with regard to what regulatory topic, you start with an assessment of the situation. In this case, you should presumably ask your people which AI tools they use already or would like to use, and in which way and for what purposes, and then you make a risk opportunity analysis and you decide whether you permit your employees to actually use these tools or not. And that results then in an AI policy and work instructions, which give guidance to your employees how to deal with this technology. And then the AI Act actually provides for mandatory trainings because they require a certain AI literacy. So you will need to do trainings at some point in time. And that is like the initial start for the compliance management system. And then it starts turning in cycles. You know, you go into a monitoring system. You run regular checks if the tools are actually used as you intended them to being used. You obtain feedback from your employees. You know, maybe they wish to use it in certain different ways. You redo your risk opportunity analysis and maybe amend, adopt, update your policies and work instructions. And then obviously also redo the trainings again, and then the cycle starts all over again, right? So that's how any type of compliance works and how it's supposed to work also in the AI sphere. Yeah, turning to the AI Act, that one is actually a quite interesting one. It was drafted already a couple of years ago and is now finally agreed upon. We do not have the official text yet. It had not been published as such, but all three European bodies which need to be involved in the legislative act did by now agree upon it. So I think that is set in stone by now. We're just waiting for the official publication in the official gazettes. What does it basically say? It basically introduces 4 different categories of AI. And the top one is the AI systems which come with unacceptable risks, those are permitted, those are prohibited per se. Then beneath that, we have the high risk category, and I will come to that a little bit later, what that actually entails. And there are very, very high requirements involved when you try to run a high risk AI tool. Then there is what they call limited risk AI systems for which the AI Act basically sets transparency obligations, that people are aware that they interact with AI, but not as high obligations as for the high risk category. And then what the EU Commission had believed to be the broadest category is that one with minimal risk, which is free to use. Actually, I don't know one, right? I don't know any system which falls into that lowest bracket. So I think, cut out the green one. Everything starts with the blue upwards. Yeah, when will this actually come into effect? It will be 24 months following its entry into force, which is 20 days after its publication, which we are awaiting basically every day. So roughly in about 2 years' time. And then there are certain provisions which will enter into effect prior to that. That is specifically the prohibitions of the unacceptable risk category, which will already kick in after 6 months, so towards the end of this year. And then the obligations for Gen AI systems will kick in already 1 year after that, so summer next year. And then interestingly enough, the high-risk AI applications, but only one category, the one which relates to EU-wide harmonized products, that will have 3 years' time until they actually need to comply with those provisions. And maybe interesting for the university here, it's free to use for scientific purposes. So there are no restrictions for AI use in science, but only until it's tested in real environment. As soon as you reach that stage, then you need to be fully compliant with the AI Act. Yeah, personal scope. So we've got a broad group of so-called operators under the AI Act, which includes the providers. That's the one who's kind of inventing the system, right? And then the deployers. The deployers are those who use it. So basically, if your company is using ChatGPT, then OpenAI is the provider and you're the deployer, right? And the most obligations are actually placed on those two group of stakeholders. Then we have further like importers, distributors, product manufacturers, which are also in scope. And then obviously, the AI Act deals a lot with the so-called affected persons located in the EU. That's the personal scope. So it's pretty broad. I don't really want to go into the definition of AI systems because that's also kind of tricky. It's more of a descriptive nature. It's not really strictly, to my understanding, a definition. So I think if you go with your basic gut feeling about AI system, that's, I think, already a very good indication for what is meant here. What obligations does the AI Act impose? Basically, upon any type of AI system that are very important transparency and information requirements. So any AI system that is for direct interaction with natural persons, there need to be an information of those natural persons that they actually interact with an AI system. So that must be disclosed. Same also for any emotion recognition system and biometric categorization systems. Those also are under very high transparency and information requirements. One of my favorite topics is the marking obligation. And, if anybody of you know how to mark AI output, please get in touch afterwards, because I didn't find anyone who can that really truly explain. Maybe Hector? Okay, we should talk about that again, how marking of output actually works. So the AI Act requires that any synthetic audio, image, video, or text content shall be marked as artificially generated or manipulated. How do I mark a text in a computer-readable format? I don't really get this. I mean, you copy and paste it, and then you work with the text, and where shall that mark be? But I'm touching down with you afterwards. So there is at least this obligation to mark the output, right? So far, we always came from the opposite direction. We try to mark what is human content, right? To assure that my IP rights are observed. But here, the AI Act actually requires the other way around. So the artificially generated content must be marked. There are exceptions for that, and that is where it has a mere assistive function within a standard editing and no substantial altering the input data, right? So any time where it has, it is not like the main tool whereby the content is created, but it's just, maybe typo corrections or stuff like that. That would be not concerned from the marking obligations. Then there are further obligations with regard to deepfakes. I guess that's no surprise, right? Everybody using a deepfake tool, so a tool which output cannot easily being acknowledged as artificially created, then need to disclose that this is actually a deepfake. And the same applies to any text which is created with the intention of informing the public, right? So basically newspapers of all sorts, if they generate their text in an automated way via AI, they need to disclose this. Yeah, and I already mentioned it, anyone using AI tools need to create sufficient level of AI literacy. I found this wording really interesting. So this basically means knowledge, right? Knowledge about how AI works and what the risks of using those tools are. High risk. So what is actually a high-risk AI? The definition refers to two annexes. The first annex relates to EU-wide harmonized products. So these are products which the EU already in prior years acknowledged as so important that they created EU-wide harmonized rules for those. For example, this relates to machinery, medical devices, toys, and so forth. So that is one category of high risk. And the second one is everything that deals with categorizing humans, so to speak. So the biometric identification system or categorization system, emotion recognition, and then plus critical infrastructure in safety systems, and everything that is granting you access to like education and vocational training institution or employment. That is the reason why, the use of AI tools in HR are easily high risk. And the problem with high risk is, with my clients, we always try to structure it in a way that you're not high risk, because actually you cannot comply with the obligation. It's impossible. Why? One obligation, for example, is to make sure that the AI tool used is never making any mistakes. Hello? The technology is not built in a way to prevent that, right? The way this technology works is in a way that it cannot 100% avoid making mistakes, right? And yeah, so we will see. There are ways to get out of this trap, and that is due to the exceptions. basically listed here. Either it's a narrow procedural task, we will find out in a couple of years' time what exactly that means, or preparation task. And basically, I would say you may never permit a high-risk AI tool to ultimately decide upon anything. There must always be a human taking that AI input and building its own informed decision, right? That's the way how to get into the mere preparational side of things. And I think we heard that before from Marlene, same as you said, you know, the decision always must remain with the humans. AI tools may only be used to get faster and maybe more reliable to a result, but it should never finally take the decision. Yeah, so consequences as just mentioned, human oversight required, and then you've got tons of obligations regarding data quality, reliability, IT security, documentation obligations all over the place. So actually, you don't really want to be in that bucket. All right, that was like a fast track through to some topics within AI and legal obligations. And yeah, that's me. Thank you very much.